welcome to the third in Linda Myrsiades' fascinating presentation about justice in early America. I think at this point we all know Linda and her background well, so I'm not going to repeat what's been said twice already. Linda, I do have one kind of question for you. Your title for this one, Crooks in the Law. You know, I'm a practicing trial lawyer, and that's beginning to cut a little close to the bone. But we'll let that one go. Well, without any more ado, Linda, the floor is yours.
Hi. Well, thanks for sticking with us. Just a second. I don't know how to get this on. Sorry. Okay. So I was asked to summarize where we're at with democracy and not to drive you crazy. So, with that as my mission statement, thus far, we've done the courts-martials, and I think we discovered something about democracy. First of all, we don't have democracy in action yet. We're in the midst of the struggle to win democracy. We don't have a legal order, as one might expect, a military order, but we find we didn't have that. We found discipline to control. The John Ford movie escapes my... no, the one, in any case, something balance, Liberty Balance. He says, before the book comes the gun. So before the law book, you have to deal with the violence. But there's also violence in law, so that's a starting point for law to kind of clear the ground. Well, democracy depends upon a rule of law in all its aspects. We talked about jurisculture, jurisprudence, and jurispractice, different levels of the law. And it needs the rule of law to cure its undisciplined nature. So we're starting from the premise that this experiment democracy, the first true democracy the world had known, first true democracy mentioned, I make that qualification, requires a balance of trust and mutuality with boundaries, but these boundaries can very easily be breached. So the undisciplined nature of democracy is where we're at. Just a second. Here. And we will find that it requires, in the same way that law requires, these elements: equality of treatment, due process, representation, voice, and, keeping in mind our frame image, trials represent a stress test for democracy. So democracy, in the bottom line, is messy. It requires a high tolerance for ambiguity and multiplicity. And if we were to follow the Italian theorist Gramsci, he would tell us that we're talking about the many within the one, the oneness of the many. You can see the possibilities for considerable confusion as a kind of theoretical position as a baseline for democracy. So we're in war mode with the courts-martial. And we're now at a point where we're going to go west in Pennsylvania and look at the law in the West. And this is a very good image to start with. This event, just 3 years before the trial of the Indian Mamachtaga, a Delaware Indian of the Lenni Lenape tribe. And it is the capture, torture, execution of William Crawford, who was the captain in the regular army that fought in the French and Indian War under the British, but was now a captain here as a member of a volunteer militia to wipe out an Indian village. He was unsuccessful, and you can see what the Delawares have done to him. So we're going to talk about Mamactaga, not as if he's an innocent victim so much as he is representative of both sides of Indian culture. Its incredible brutality, its defense of its land rights, and then, of course, its victimization by white culture. So we're going to be dealing with a frontier-style popular form of justice as we start our tour, and then later in the series of trials we'll go to the East, where we'll get a much more flamboyant, lawyer-based, rhetorical kind of law and trial. Here, if you notice, he is circled with fire. This is a print from the Library of Congress that goes undated, and this is a more elaborated version of that early print. So this Battle of Sandusky and his capture ends in his being tied to a pole by a leash. 70 rounds of gunpowder were shot at his naked body, and then Indian women, largely, surrounded him and poked him with burning poles to light the gunpowder. This went on for 2 hours. He kept running around the stake, and they kept chasing him. They cut off his ears, scalped him, threw his scalp repeatedly in the face of the other captives, and tossed shovel loads of burning coal on him. So this was a practice, and if you were lucky, your execution would be that you would be tomahawked to death by the women of the tribe. So this gives you at least a kind of brutal image of the frontier. If we can change the slide. No slide. Help. Okay, and you saw this before, the first opening lecture. I introduced you to Kilbuck Island. And 3 years before the trial at Mamactaga, there had been a massacre on this island of peaceful Indians. It's at the very foot of Fort Pitt, which at that time was commandeered by the Americans. It had quenched that war. They joined Pontiac's War in 1763 at the end of the French and Indian War, which was an Indian rebellion that ran from Lake Superior to the southern Mississippi. The Shawnee, the Seneca, and the Delaware ran that war in Pennsylvania. They wound up losing that war for the Indian Confederacy. And then the Delaware made a peace treaty in 1778 with the Americans, and the deal was supposed to be that because they made that peace, the British would be unable to open a second front in the West. There was already a transatlantic frontier that the Americans were fighting on, and it actually helped them win the war. They were not greeted with any gratitude from the Americans. In fact, in the 1780s, as a prelude to this trial, a series of massacres occurred where the Delaware Indians were the particular target, and the Sandusky battle that I just showed you a print from was one of those assaults attempting to massacre the Indians. So that's the prehistory. The massacre here at Kilbuck Island is part of that prehistory, and Kilbuck Island would be right at the intersection to your upper left of those two rivers, Monongahela, and I think it's the Allegheny, I can't see. It was actually a sandbar. It was originally called Smoky Island, and it was called Smoky Island in remembrance of the fact that that island had traditionally always been used by the Delaware to torture their victims because it was right under Fort Pitt, and the white man could see what the Indian was capable of. And so because of the use of coals, they called it Smoky Island. It was thereafter called, let's see what they called it. So it was called Kilbuck after they made an alliance with the English, after the chief of the Turtle tribe of the Delawares, John Henry Kilbuck. And then subsequently it became called Good Liquor Island, because that's where all the Indians who came back from the war would set up camp and drink themselves basically to death. And so by 1785, on that island, we will have our trial. And the next slide is the court in which the trial will be held in Hannistown. We'll wait for that. Somebody up there? There we go. This is a reconstruction in Hannistown, Westmoreland. This is the first court house west of the Alleghenies. It was set up in 1773. And it adjudicated cases from 5 Garrison, Fort Garrison here, 30 log houses, 2 taverns. And this was Robert Hanna's house, and it was a tavern, and it was the courthouse. Now in 1782, Hannistown was burned down by the Seneca Indians. Remember, they're allies of the Delaware. And that's going to be 3 years before the trial, but the courthouse survived. Okay, so we can take that down now. There's another slide which I am not going to talk off of. Well, this would be, if you can't really see it anyway, so that's good. But in 6 iterations, in 6 iterations, if you were to treat the entire trial, you would do the history of the Delaware Lenape Indians, the state of the law regarding the Indians. You would go on to Mamactaga's case, then we'd do the trial, and then we'd make comments on cultural perceptions and afterward on the fairness of the trial. So I will sample from among those things in my talk. We can take that down now and just put the lights up just a little bit. So, what are the elements of this case? Well, first, now you have to look at me, haha. Well, first we have the Indian Mamactaga, who was a terror even among the Indians. He was regarded by the American judiciary as the most bloody caitiff of the Delaware tribe, caitiff meaning a cowardly, despicable figure. So he had a real history here. His mark was a turkey foot. He would stamp that or carve that on any pelt or fur that he would kill and sell. And his nickname was the Hurricane, which stood for his kind of ferocious nature. So, housekeeping. He had a very bad reputation, in other words. So we start with that figure. It's not going to be an Indian who's innocent, who's going to be victimized by the whites. This is going to be a fair fight, this trial. And then we have the defense counsel and the judges who are going to be involved in this. And this is going to be interesting. The defense counsel is Hugh Henry Brackenridge, whom we will meet again, very expert Western lawyer, but he was as eccentric as they come. He used to walk around in his bare feet in the courthouse, and he wrote a famous, possibly the first American novel called Modern Chivalry, which is about John. Okay. I think we're finished with the housekeeping. Modern Chivalry, if you ever have an opportunity to spend 3 years reading a novel, please do. It's in 9 volumes. It is very funny, and he is very much like Mark Twain, and if there's somebody he doesn't make fun of, he's an equal opportunity offender here, I would be surprised. Any rate, it is about what America was and what it was about to become from the late 18th to the early 19th century. So he's going to be the defense counsel here, and he's going to show up in 2 other trials. The George Washington land case, where he is going to be the defense counsel of the settlers who George Washington is suing, and then he becomes a rebel in the Whiskey Rebellion. And then he becomes, interestingly enough, a Supreme Court justice in the Pennsylvania Supreme Court. More important to be a Pennsylvania Supreme Court justice than a U.S. Supreme Court justice, because this is where all the action was happening up till about 1800, 1810. And then we have the Pennsylvania Supreme Court justices Justice McKean and Justice Bryan. George Bryan was not the brightest light in the pack of the Supreme Court, but he did some things that were right here. And he had to do them up against the Chief Justice, McKean, Thomas McKean, who was an arrogant and somewhat vicious man, who later went on in 1799 to become the governor of Pennsylvania. And he will show up again. So these are the three powerful figures that we'll be dealing with in the trial itself. Of additional interest will be, as characters, three justices of the peace who, when it came time to have the trial, didn't know what law to apply. Now, this should give you a good idea of where we're at with the law at this point in history, that it was unclear who, where, and how a trial should be held with regard to a murder by a member of the Indian nation against the white American nation, let's say. And that's going to be a problem for a number of reasons. But these three justices of the peace wrote to the general of the militia, Irvine, wrote to the Pennsylvania Supreme Council. We did not yet have the bicameral legislature and governor that we had after the U.S. Constitution came into play. And then separately wrote to the Pennsylvania Supreme Court to say, how are we going to do this? Now, they should have known, because in 1773 there was already a county court established, which was a post-colonial county system, which was tied into the upcoming new American government, or was tying itself in, so that after 1778 we had the establishment of a state government under this new American government. We didn't have the Constitution yet till 1787. So you can see that they're each appealing, each of these justices of the peace are appealing for clarification on the law to whomever they are politically affiliated with. If you're affiliated with the Pennsylvania Supreme Court, you'll ask them. The Executive Council means you're going to the executive branch of the government to ask them. So now the military and the executive are involved. And the third one was, who did I say the third one was? Pennsylvania Supreme Court and militia, the militia, right? Then you go to the militia. One of the three justices was himself responsible for two of the massacres in the 1780s that predated this case. He had gathered up some volunteer militiamen himself and attacked and massacred two innocent villages of Delaware Indians, some of whom were affiliated with the Moravian missionary colony at Ganuduten. Sorry, my German sucks, but it's as close as we get. Very important event in Western history, by the way. Okay, so one thing we should explore just slightly is how the whites perceived the Indians and how the Indians perceived the whites. So we know that under William Penn, because we addressed this in our first lecture, he had made certain promises to the Indians with regard to the treatment they would receive under white law, that they would, and this is now a quote from a letter from William Penn to the king, Tamanend, the Delaware chief king of the king of the Indians in Pennsylvania. Shall offend you or your people, you shall have a full and speedy satisfaction, so a speedy trial, for the same by an equal number of honest men on both sides. You will have equal representation of 6 Indians, 6 whites, which is what's called a demediatate linguae jury, or a half-tongue jury. And this is a strategy that comes from the 14th century Dutch merchants in England who did not speak English, and so they were allowed a half-alien jury. But that jury did not have to be Dutchmen and did not have to speak the same language as the Dutch, just that they were aliens like the aliens who were being tried. And that was the strategy that was applied to the Indians as well. Did not have to speak the Algonquin language of the Delaware Indian that was being tried, and did not have to be a member of the same tribe as the Delaware Indians. So how much representation they would get in that case would be problematic. They would respect, under Penn's law, and we're going to make this a checklist for us now to see if any of these promises are kept in Mamakdaga's trial. They were going to respect the tribal hierarchy by making sure that notice is given to the king of the Indians. They refer to him as a king, but in a small k, not a capital K, so as not to confuse him with the King of England. And that we shall see justice done, and that's going to be important because there's a 1744 law under the Penn proprietorship that will guarantee that the Indians will be treated effectively, in effect, like the white man. That if it's a capital crime, they will have access to a defense counsel, that they will have witnesses who are sworn under oath, and there are other qualifications. But in 1780, Pennsylvania also passed a law whereby the slaves in Pennsylvania would be gradually emancipated and will receive, even under their slave status, all the rights, judicial rights associated with any other inhabitant in the state, meaning that they would receive justice in the same way as white men and the other colonials would. So this is of interest because it makes Pennsylvania an anomaly among the states, because it was the first state to gradually emancipate slaves. Of course, it took them 65 years to do that. So these poor emancipating slaves were totally unclear about what they were, what their rights were or were not for 65 years after 1780, which was extremely problematic in terms of the legal system. So basically, Penn's bottom line was, don't abuse them, but let them have justice and you shall win them. And you might be surprised to find that in Mamakdaga's trial, if we went down this checklist, he is going to receive treatment that will be unexpected. I mean, we might have expected that he would be ramrodded. And the only way he would have been ramrodded would have been if he had not gotten access to a court trial and he had been left to vigilante justice, which was the justice of the frontier in the post-war years from 1783, which was the date that the peace treaty of Paris was signed, and we won, which clarified that we had won the war against the British. From that point on, the West, because it prevented a second frontier from being opened against the British, was given relative autonomy in terms of self-governance. And that relative autonomy came along with the establishment, yes, of county courts, following Hannah's court that we just saw. Others were opened in the 1780s in the different western counties. But that self-governance really meant that the voluntary militia, because we did not have a standing army under the Constitution even, that was the policing force of the community, which had all the rights of a regular army, and was considered the arm, the executing arm of the judicial system. So vigilante justice was authorized, was relied upon for order. And there was a real question about whether Mamakdaga would be given access to a court or whether he would be turned over to the militia, which explains why one of the justices of the peace wrote his letter to ask how, why, and where do we try this guy to the general of the militia, of the Pennsylvania militia, Irvine. So that was the promise that was made. And there were some trends in the law that are of interest here. white community was unwilling to consider that there could be a sovereign Indian nation coexisting with, or inside or within the bounds of, an independent commonwealth. And to give Indians equal rights and to give them their own tribal councils where Indians could try Indians meant that you respected them as an independent and sovereign nation within a nation, which is the kind of law that you're going to get from the Supreme Court, U.S. Supreme Court, when they start adjudicating cases relative to Indian law. Well, in the West, they weren't having it. So that was one problem on the white side of it. The other problem, of course, was militia law. Let me just go back to here. All right. Another problem that the whites had was that they felt the Indians got special treatment above and beyond what settlers in the West got by virtue of the treaties that they had signed with the government of the state of Pennsylvania or with the new U.S. government. They felt that more whites than Indians had been called to court. And that was done consciously by the government because it wanted to respect the fact that Indians had the right to just treatment, but also they wanted to preserve the peace and to prevent Indian reprisal, especially in the 80s when there were all of these massacres. So they wanted to ensure that they had access to the courts, and that meant that they could call white men to trial in white courts. Well, the whites were not very happy about that because Indians went to the Indian councils if it was an Indian on Indian crime, and Indian councils were very lenient. That became another problem for white Americans. The title of this talk is Crooks of the Law, as Fred generously referenced, and it actually did not refer really to lawyers. Crooks of the law meant the technicalities or the crookedness of the law. And Indians tended to get off on technicalities when they had representation by counsel. So that became another grievance. As a result, local juries, which were exclusively white, refused to convict whites who had committed crimes against Indians, and they would effectuate rescues or escapes, and local judicial officials, particularly justices of the peace, would accommodate them. They would, juries won't convict, judges will not direct jury verdicts of conviction, and in addition, they would assist them in helping them to escape or be rescued, the whites who had been committing crimes against Indians. What the complaints that whites had against their own courts was that they wanted local courts to adjudicate crimes by Indians, not distance courts like the one in Philadelphia. And yet there was a law in 1748 that basically said, in order to avoid local prejudice against Indians, Indians who are not close to habitated centers should be sent to Philadelphia for adjudication, which meant they would be sent to either the county court of Philadelphia or to the Pennsylvania Supreme Court in Philadelphia to have their cases adjudicated. County courts, interestingly enough, conducted most of the business that had to do with law from the colonial period right up through until the U.S. Supreme Court became fully established in the early 19th century. So they were powerful courts, and they were given the rights of what's called oye and termine, which means criminal courts, up to the point of when it's a capital crime, and then it becomes, okay, who shall we allow to conduct capital trials? And so the mediating or negotiated position was, it might be better off for everybody. And now there are a lot of judicial reform bills that are coming out along at this time. might be better for everybody if we gave that right exclusively to the Pennsylvania Supreme Court. And of course, the county courts, which all along had been doing all the business of law since the colonial period, were very much opposed to that. And that will be an issue in this case as well, who shall conduct this trial. So one of the JOPs, Huffnagel, writes to the, Armstrong, writes to the Executive Council and says, we want a special commission. That means that the President of Pennsylvania, he was president at that point, not a governor, and the Executive Council could assign special judges and create their own court to judge this Indian, right? Now, the Supreme Court is going to have a fit about that, and McKean will not allow that to happen. He's the Chief Justice of the Pennsylvania Supreme Court, because it takes away their jurisdiction. And the argument will be that he and Bryan will make is that this gives you prejudicial powers to select who you wish to judge this case. And it also disturbs the relationship between the executive and the judiciary. And he's going to win, because McKean has been around longer than anybody else, and he can holler louder than anybody else. Plus, he's sitting pretty in a position where he doesn't have to be elected. When you talk about lifetime appointment, he was Chief Justice for 22 years. So he wins that fight. All right. Just quickly, what are the problems from the Indians' point of view? The Indians felt that their tribal councils were not respected. In fact, they were considered inferior because they couldn't try whites who committed crimes against Indians, but Indians who committed crimes against whites were tried in white courts. That's a problem, especially if you consider yourself a sovereign nation. Plus, their theory of the law was proportional atonement. In other words, if I injure you and I atone proportionally by payment of furs or certain privileges, and I get the consent of the victim's family, because this is based on clans and kinship groups, not individuals. You have to accommodate the kinship group. If you commit a crime against an individual, there's no such thing as individual crime in the Indian councils. Then that should get you off. And forgiveness, rather than punishment, was the model that was used by the Indian councils. So that was not respected. There was no reciprocity between the white courts and the Indian courts on that issue. So they did not feel that their traditions were represented fairly. And then the other means of adjudicating were rituals of cleansing. You can cleanse away a sin, they don't use the word sin, the crime, through a ritual. Well, this is not going to be the white man's way in the white man's court. They did not believe drunken crime should be punished because it was the liquor rather than the man. We didn't try women for some reason that should be punished. And drinking had this long-term history that went well beyond the crime itself, so it made it very difficult to adjudicate that as a crime. The white man provided drink to the Indian, used it as part of treaty negotiations to get them drunk so that they could get more favorable treaty conditions. Traders used it in order to steal fur and the goods of the Indians that they were bartering with. Missionaries found that drink prevented the Indians from becoming peaceful and being converted. The government actually, in the middle of the 18th century, banned all alcohol. But no one, they couldn't enforce the ban. So the government had an interest, because of Indian reprisals and Indian crimes committed under drunkenness, to not want drunkenness. It became a very complicated issue. But when you study case law and you add up all the cases in Pennsylvania case law of crimes committed while drunk, first of all, they don't record Indian crimes except land crimes that have to do with titles in this case law. So what you can do is you can collect the white crimes under drunkenness. You would find that whites routinely are not for murders while drunk, only 1 in 5 cases actually are punished by hanging. The rest are either get hard labor, or it's called self-defense, especially if there's one case that was against an Indian. When it was against an old man, he got 5 years. They murdered an old man at a wedding. A woman was thrown on a fire repeatedly by her husband and refused treatment by a doctor. He got hard labor of 2 years. So it looks like the female, and the Indian weren't treated particularly well under drunken crime law. So this body of law, I hate to make comparisons with women's reproductive rights law, was not very effectively argued. And so convictions were very rare, with the exception, of course, of Indians. In drunken Indians, the crime itself and the trial, which takes us to Mamactaga's case. So, on Kilbuck Island, Mamactaga had gone there to drink. He rushed into a cabin on a camp, which was populated by a number of Indians, Delaware Indians, who had come there having just been after the war. That's the terminology that was used. They had come in being just after the war. In other words, they had repaired there, having fought with the British, even while their tribe had a peace treaty with the Americans, not to fight against them. So you could see that there's already a prejudice against this group of Indians. He was all liquored up already. He killed 2 men and stabbed 4, so there were 2 wounded, 2 dead, and claimed the next morning when he woke up that he had no knowledge of the events. He refused a plea because his claim was that he had no memory. He didn't understand that he could plead not guilty or deny the crime, because in the tribal councils that was not a way of doing business, so he didn't understand that. There were several things that he didn't understand that are worth noticing. He didn't understand, for example, what voir dire meant. You could challenge. That's one of the rights the Indians was given when they could be treated like all other inhabitants. You could challenge jurors. When his interpreter explained to him what it meant, he tried to challenge them by the look on their face, which of course wasn't going to get him very far, whether they were smiling or frowning. He didn't understand that he had the right to what's called a neck reprieve. A neck reprieve is where you ask for benefit of clergy for your crime, and if you can recite a verse from the Bible, you no longer get the, what do they call that? A capital punishment, right? He would be free from being executed, and then they would brand him so that he couldn't claim that again for another trial, which is why it's called the neck reprieve, the neck being the hanging. He didn't understand that either. When they came at him with the brand, under the presumption that he could qualify because of the Moravian missionaries, he bolted and refused that as well. So he didn't get his plea, he didn't get his neck reprieve. There were several factors here that were cultural that interfered with his ability to get what you might consider a fair trial, or at least the benefits of all the legal technicalities that he could claim. But other than that, we'd have to see whether or not we think he did get a fair trial. So he's taken to a pit at Fort Pitt. And the pit is literally a root cellar, which is 8 feet deep. And he's kept there for 6 months till he's tried. When his lawyer comes to interrogate him, he has to look down into the pit, and the translator or interpreter has to interpret for him. And that's how they talk to one another. It was a black hole. It could hold 2 or 3 men. It was used as a brig for the soldiers at the fort. The local militia wanted to assert its authority, and it attacked the fort, 50 members of a party, and it was the official militia of Washington County asserting its authority. And they tried to break down the dungeon. The commander standing guard on the fort stood up in favor of the Indian. They put a gun to his belly, and local inhabitants came and rescued the commander. So you can see there's a mix of feelings about justice, power, relationships with the Indians, etc. Everybody didn't think the same thing, which of course is we might anticipate. And then the inhabitants took over the fort and guarded it until reinforcements could be sent from an army serving in the Ohio Valley, which took some time. So they actually guarded the Indian and saved his life. Meantime, that militia threatened the interpreter with a hanging, and they chased him into Indian country. The interpreter, who had been hired for his cause, had been a captive of the Indians since he was a child. So it's interesting that he did not have an Indian interpreter. Usually they're either missionaries, traders, or ex-Indian captives who did the translations. Which meant that in the trial itself, Mamataga would not have had somebody to advise, counsel, consult him in his own language, nor to stand up for him, right? So that business of having half of a jury being made up of, in quote, aliens, half Indians, half whites, was important because those 6 jurors would, in fact, when a justice would allow that kind of a jury, they would actually advise, consult, and advocate for their fellow Indian. And he did not have that benefit. Now, presumably his lawyer should have done that for him. And in fact, Brackenridge tried to represent him fairly with the defense of that he had been provided the drink by white men who purposely got him drunk, and there was a lot of evidence to that effect. But Chief Justice McKean not only refused the jury of half Indians, but he refused the plea of drunkenness. So he had essentially no legitimate defense to go back on. Since he wouldn't confess to the crime, he wouldn't admit he had done something wrong because on his honor, he didn't remember what had happened, and as an Indian, he wouldn't confess on those grounds. So we are close to the trial. We've covered case law. There is one witness to the event that could have testified and might have clarified the nature of the punishment that the Indian might get. Unfortunately, he was a dwarf. He was one of the victims who had been stabbed. And children, women, Indians, blacks, slaves or free men, and dwarfs were not considered, even under oath. They were not disallowed the oath, by the way, but even if they had been under oath, in one case, the famous case we're going to study, the main witness will be a child, in fact. They were not considered witnesses who were qualified, and so their testimony was discounted. And since he was said not to be a man grown, he was disqualified. So that testimony was denied the Indian as well. All right. So I want to leave some small amount of time for questions. We had one question last time. That was one up from the first time. So if we were to summarize whether or not Mamataga got a fair trial, we have to consider this, and this is now anecdotal, but it is telling. He was asked, as he was taken from the courtroom after he got the judgment that he was convicted and would be hung, he was asked who he thought those men were who were sitting up on the bench. And at that time, they still wore scarlet robes, as they do in England. And that is a carryover from the colonial period. And he had been associated, as the Delawares were, with the Moravian missionaries. So his response was that he thought the Chief Justice was God and that Associate Justice Bryan was Jesus Christ. So I think that will give you some sense, even if it's anecdotal, of how well he understood the court, its laws, under which he was going to be, under which he was in fact convicted. So this, in my view, if we were to look at this case and do the checkoffs that I had suggested before, he was given a very high quality counsel, right? And Brackenridge, as I said, went on to become Pennsylvania Supreme Court Justice, and he was intent on giving him full representation. But that representation, under the defense that he was drunk and been supplied that liquor by whites, was disallowed. So you can't say it was the fault of the counsel. He did get the Supreme Court justices and not a local court, or a county court, or a JOP court, Justice of the Peace Court. So the prejudice that would be contingent upon having a Western court or a lower court who would be more responsive to local sentiments, I think that's off the table. He did, however, have a local jury, and that was the compromise, because it was the Supreme Court on circuit, because you did a lot of circuit riding at this time. Even the Supreme Court did circuit riding, which was a lot of people, important people, would not accept appointment to the U.S. Supreme Court because it involved a lot of circuit riding, which is very, very difficult. So this is the Supreme Court on circuit in a county court with a local justice. So there's a kind of a compromise there to get everybody on board for this trial. So there was local representation, but it was offset by having the Supreme Court justices. And I can't say that he was ramrodded in that sense. So in a lot of ways, oh, by the way, the king of the Indians was notified. That was the first thing that that was done by the inquest that was held to determine whether or not he should be brought to trial. They called the king of the Indians to come and gave him notice to attend the trial. So he was tried in a fair trial. His trial ended in a verdict which was unlike the verdict that whites received, that's for sure. But you can see at least an effort here not to have ramrodded him. So my final comments about this is what do we take, what's our takeaway in terms of where we're at in terms of developing democracy? Well, we find the Indians here have been, we use the term deracinated, deculturated. They've been separated from their identity as a tribal people, as a sovereign nation. Their traditions, their rituals are not respected in the white man's court, although they are allowed their own separate courts. They have lost their personhood as natural stewards of the land because they've been deprived of their land through treaties and through thefts and through massacres. They're struggling to assert themselves in the white man's land, and the court is a place where they can go for refuge from vigilante or militia justice. So there's that about what's happening in the West in terms of what's called backwoods or backcountry democracy. It's not perfect. It's still trying to bring order to chaos. He was deprived of a whole set of obligations and benefits that had been distributed across his own people, the people to whom he belonged, by virtue of being in a white man's court. He was uniquely alone. Remember, they don't consider individual conduct, but conduct in terms of the kinship group. So he's been stripped of his clan and deprived of his honor. These are the real costs to the Indians rather than that they didn't get a fair trial, in the sense that fair trial, in the sense that maybe no one got a fair trial under frontier courts in any case. So that's beyond this, he was denied some other things as well. I want to give you one last anecdote before I finish, just to show the nature of Malak the God as a person. He was on the gallows, and the rope broke. He fell to the earth, he rose with a smile, and went up again onto the gallows. And his only sentiment was that he would rather have been shot or tomahawked, but that he supposed that whatever he had done, though he didn't know what he had done, the good man above would excuse him. And that was how he ended his life. Okay, so I am open to comments, complaints. Yes?
One thing, maybe I got it totally wrong, but I could never.
David, we can't hear you. You need a mic.
One thing I've assumed is that the various tribes were really, they were aware of each other's existence, but they had to be completely different, I would assume, unless there was something that held them together more than I would think. Now, they were at great distance. Of course, there was transportation. But there must have been vastly different types of Indian courts, depending on the tribe.
Yeah, you have to appreciate that my sources will be essentially traders who have lived among the Indians. James Adair, for example, lives 40 years among the Indians and produces the most interesting of comments on tribal justice. He lived all over the place, so we're going to get a lot of mix, and he doesn't identify whether it's a Cherokee justice or Navajo or Shawnee or what. So that's one problem. The other thing was that the white community essentially, at one point under Penn, they preserved the identities of the individual tribes. Gradually, over time, the tribes began to be treated as Indian, just capital I Indian, all of them as if they were the same. And at that point, that's when anti-Indian animus really began to generate, when white culture could see it as us against them, this kind of otherness. Yes, so there are historians, anthropologists, ethnologists who are able to make those distinctions and make them in exquisite ways. But if you're talking historically, the pattern was to aggregate all Indians as one and not to distinguish them as tribes. It made it easier to discriminate against Indians as Indians. Is that, yeah.
Excuse me. If I could make a comment, David, if I could make a comment, well, if I could make a comment, David, to your question. I wrote my undergraduate thesis on an aspect of, our relationship with the Native Americans, and one of the things that struck me very hard is that they have no written language. So any history that we have is written by folks that look like us, not the Native Americans, and that's to the victor writes history.
Questions, anyone else?
What's it?
I guess you're off the hook again.
Not quite.
No, we have a question.
My question relates to the people that acted as attorneys, or they call them attorneys, but represented people. Did they require any particular background or education?
Yeah. The case is that lawyers as a profession, or the legal profession, did not generate until the mid-19th century. Until that time, you could there were bar associations, but they were largely in cities. And you apprenticed to the law by serving under a lawyer, or you read for the law. But very uneven across the board in terms of your training. And I must say, and we'll discover this in the next case, that being a good politician and knowing how to count, if you go before a Supreme Court, who's going to vote in which way, and getting to know people, that is the judges, by traveling them, they actually use the word chasing them across the circuit. That is just following them like groupies as they ride the circuit. That was the way a good lawyer, certainly in the West, learned his craft.
Linda,
Go ahead.
Sheila.
Were there any Indians who refused to get hanged?
There were Indians who refused white man's justice.
Yes.
And there was a provision for that. In the event that you made that choice, assuming it was a choice, you were, the only justice you would get would be called ex parte. It's a summary form of justice, where the court would actually allow you no defense whatsoever and would make a judgment on your case without your ability or right to bring evidence before the court. So it wasn't a good play to make. Here's one back.
For comparison, what would the penalty have been for a white man who had committed the same crime?
That I tried to speak to that in terms of having studied the case law. The case law that was available, that is available to me, are the law reports done by Alexander Anacid, who is the president judge of the Western courts, but he did not start collecting these court reports until the late 1790s. So I'm not going to get contemporaneous reports. Separately, the greatest number of cases that involved Indians at all had to do with land titles and whether individuals could purchase a land title from an individual Indian rather than from the tribe itself. Take that aside. All I could do, because there was only one case that had to do with an Indian murder, and it had to do with the murder of an Indian rather than by an Indian, because they weren't reported in the case reports. The only thing I could do was study the ones that had to do with the type of crime that he committed. And there were only 5 instances of that, and all but one, which was incredibly egregious. Well, the others were egregious, the man who threw his wife repeatedly on the fire, etc. They all escaped being hung. And whatever other punishment they got was really not for an aggravated felony of the type that they had committed. I don't know whether there was some kind of accommodation made because it was in the frontier and life was rough, and maybe if it had been a case tried in the East, it might have been different, but there are no records for me to follow there. I'm sorry about that. Yeah. You took it back there again.
So yesterday, a few of us gathered and read the Declaration of Independence. And to the point of us versus them, there is the charge against the king that he supported savages. All Indians were lumped together as savages.
Yeah, let me give you the quote from the Declaration of Independence that, in fact, addresses just that issue. The grievance against the king was, as quote, I quote, that the British excited domestic innovations amongst us, and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. So it shows you an extreme anti-Indian bias that existed even among Eastern intellectuals at the time of the writing of the Declaration. And from this point forward, develops what's called the myth of the vanishing Indian. And they had this support in the Declaration for it. The idea that coexistence with Indian culture was not any longer possible, and that the Indians should either entirely assimilate or disappear. So that was a very important piece of history, that statement in the Declaration. Had it not been there, it would have been a little helpful. Richard, we had a comment here. Kind of lost track. Right there, right there.
Oh, sorry.
Did the Indians ever catch on to the system? You would think that they would at some point want to defend themselves in a manner that would be productive for them.
Yeah.
And don't they catch on that the drinking is problematic?
The Delaware Indians as a tribe petitioned the Pennsylvania government and the New American government to outlaw supplying alcohol to Indians. And as I said, in the middle 18th century, that was in effect, but they couldn't make it happen. And it had become such a tradition to give Indians drink for all kinds of reasons, to seal pacts, to sign treaties, etc. So it became kind of a ritual as well. No, it had no effect whatsoever. Did the Indians catch on is an interesting question. Indians started bringing white men to white courts to charge them, and they became, in fact, very proficient at it. You can imagine that wasn't going to last long when the courts realized how effective that was happening. And by the way, the Indians who were becoming assimilated and had been in villages that had been run by missionaries, they're the ones that were able to do that. But those Indians were massacred by militia. They were chased out and forced into the Ohio Valley, so that for Pennsylvania itself, as we're studying it, that practice becomes less and less important. Okay.
If there are no more questions, because it is after
Thank you
4 o'clock.
for asking so many questions. That was terrific. I'll try and be more amusing next time.
The next talk in the series we'll go back to the regular schedule, which is the second Monday of the month at 3:30. We changed this because